Good afternoon, and welcome to today's virtual CLE entitled Identifying AI Legal Risk Areas of Focus in Developing and Using AI Tools. I'm Tom Rosenberger, Assistant Dean for Online Programs here at Albany Law School. This program marks the launch of Albany Law's brand new CLE series on cybersecurity, privacy, and data protection, a critically important and rapidly evolving landscape of issues and opportunities. The series underscores our commitment to building a global online community that offers innovative and accessible programming for lawyers and other professionals whose work puts them at the intersection of technology, law, and business. Over the next 9 months, we're offering a slate of programs on topics ranging from AI risk assessment, regulation, boardroom readiness, and Fourth Amendment concerns in relation to cybersecurity, privacy, and data protection. Each program includes expert speakers who are practitioner faculty in our online degree and certificate programs in cybersecurity and data privacy. Programs in this CLE series will satisfy the New York State Bar Association cybersecurity CLE requirement, and we invite all of you to consider registering for our upcoming programs today. I will provide the link in the chat as soon as I'm finished with my introduction. I have just a few additional housekeeping items before we hand it over to our speakers. This webinar is being recorded and will be posted publicly. However, CLE credit is only available for those who are in real-time attendance and capture the code word, which will be announced at some point during the program. Attendees seeking CLE will need to return within 24 hours the fillable PDF that my colleague Lisa Rivage provided to you via email. Today's agenda is quite full. However, the speakers do welcome questions via the Q&A panel and will seek to reserve some time at the end for questions. At the conclusion of today's program, we ask that you please complete the evaluation form to let us know how we can continue to improve our offerings. And we are already thinking about the 2026-2027 series. So please do provide on that form any topics of interest that you think should be included. Without further ado, it is my privilege to introduce today's speakers. Antony Haynes is Director of Cybersecurity and Privacy Law and Professor of Law at Albany Law School and is partner at Dorff, Nelson & Zauderer, where he serves as head of the Cybersecurity, Data Privacy, and AI Practice Group. He has extensive litigation experience in the intellectual property, securities, and criminal defense areas. Prior to practicing law, Antony was an assistant professor of computer science at the U.S. Air Force Academy. Professor Haynes teaches courses on national security law, artificial intelligence, bias in the law, and more. Amy Apostol is the Assistant General Counsel for Cyber and Emerging Technologies at Leídos, a Fortune 500 innovation company that provides technology solutions and solves critical national security and health challenges. Previously, she served as Chief Legal Officer for the Intelligence and Security Academy and has served in several senior counsel positions across federal agencies. Professor Apostol teaches courses on cybersecurity and public policy, supply chain cyber law, and global data privacy. Professors, please take it away.
Good morning, everyone, and thank you so much for joining the Albany Law School's online graduate program CLE series. As Tom may have mentioned, this is the first of a series of presentations, and this will become a perhaps bi-monthly activity, so keep your eye out. As mentioned earlier, I need to share my screen, don't I? I should go ahead and do that. Let's go ahead and share screen before I dive deeply into the programming here. So we want to share a screen, and hopefully you're able to see the PowerPoint slide. And Amy, give me a thumbs up if you're able to see it. Excellent. So as you can see from the slide that I'm now showing, today's program is identifying artificial intelligence legal risks, areas of focus in developing and using AI tools. As Tom mentioned, I'm Antony Haynes, and with me is Amy Apostol. Together, we blend academic, technical, and in-house perspectives on AI regulation. This session is really important for several reasons. Here are two. AI is moving, and I believe has almost entirely moved from proof of concept to mission critical areas, particularly in the legal area, and our exposure to the AI risks are expanding just as fast. So, our goal for today's CLE is to equip you to spot, prioritize, and mitigate the most salient AI related risks before they become litigation or enforcement headaches. So, our agenda here is pretty simple. For this 1 hour CLE, we'll start with the fast moving and fast evolving regulatory environment, the EU AI Act, US executive orders, and state initiatives. Then we'll drill into 5 separate buckets: IP, torts, employment, privacy, and this idea of governance. And then we'll close with an actionable checklist and key takeaways you can deploy on your Monday morning when things get started. So, to engage us, please feel free to drop questions in the chat as we go along, and we'll be happy to pause at natural breaks to address your questions in the chat. Materials with citations and practice tool tip sheets will be emailed after this session if you have not already received them upon your registration. And again, this program will qualify for a 1 hour professional practice CLE credit. Please ensure your attendance code is entered when we tell you the special code. So let's begin with Amy framing the regulatory landscape that shapes every downstream risk conversation.
Thanks, Antony, and thanks everybody for joining us. I'm really thrilled to be here with all of you and talking about something that is near and dear to my heart, my work on a day-to-day basis, and the education that we're providing at Albany Law School. So we're going to jump in with an overview of the regulatory environment. And we really want to set the scene here for everybody as we do dig into those different areas that Antony mentioned. We want to really give you that overarching sense of what do we actually mean when we're talking about AI law. And a lot of you have probably heard about the fast moving and evolving landscape around AI specific requirements, but it's really important to know that when you're working in an AI context, it's not just those AI specific rules that you need to be tracking, but you also need to be thinking about AI in a broader sense, in a bigger picture way that brings in existing legal frameworks that we're already using in a very dynamic and cross-functional way, whether that is the privacy area, intellectual property law, tort law, employment law. There are a lot of different existing frameworks that you need to bring in to your practice of AI related work. And so, for that reason, it can be very helpful to partner with different lawyers that have those subject matter expertise, and really kind of bringing that to the fore. So you have this kind of 3 different things going on. You have that existing law framework, and interesting new and novel ways that those things are applying to AI. You have a whole landscape of AI specific requirements. And then we have a very burgeoning set of interesting litigation topics happening out there that we're watching all the time. A strong body of litigation is evolving around intellectual property. And more recently, we're starting to see a lot of privacy related litigation bubble up. And that case law is really going to shape the way that we ultimately view and operationalize these AI requirements. So I think we can move over to the next slide here. I just wanted to provide a little bit more context on the AI specific law landscape, really to underscore how complex and fluid this environment is. So within the United States alone, we're seeing just massive amounts of proposed legislation, specifically at the state level, where over 1,000 bills have been proposed. Not all have been enacted, but we're just seeing a ton of legislative activity at the state level. Now we're also seeing some additional movement at the federal level with some new executive orders and an AI action plan that just came out of the administration within the last few days. We're really starting to see from a top-down perspective within the US what those focal point areas are going to be and what those priorities are. We're very much influenced across the board, and particularly with the state level activity by the global environment. So just like with privacy, We're seeing the EU take a front runner position on AI. We're also seeing, that's a leader, but we're also seeing other jurisdictions around the world really come online with similar style, comprehensive AI regulations. So it's kind of, again, very much a patchwork approach, consistent with what we saw with how privacy law has evolved. And then finally, just touching on a couple of the hot topics here, I think a lot of this is what we're going to be talking about in a little bit more detail today, but just some themes that I think are important for you to have in the front of your mind as we go through the conversation. So still a lot of focus on consumer protection, transparency, safety, risk, some different rules depending on what sector the AI is being deployed in, and then continue to focus on bias and discrimination. Antony, anything else you want to jump in and mention here on this topic?
No, Amy, I think that this is an excellent overview you've provided.
Thanks. So yeah, I think, as we just kind of round this out, we can move to the next slide and just kind of look at some of the practical tips here. I'm not going to get into all of them. You'll have this as a takeaway. But I think that complexity, really thinking fully and in that multi-dimensional way about AI and what existing or new legal frameworks may apply, and really keeping a pulse on this environment, making sure you're up to date on what's happening out there across those three different areas, and just sort of being ready to think about things in a novel or creative way as this continues to evolve.
Thank you, Amy. So I'm going to spend a few minutes talking about some of the intellectual property risks. Now, this is a really big area, and the focus of this segment will be on the copyright area since it's so interesting and probably the most impactful to the greatest number of attendees. But initially, when we think about this, I'm going to jump to the bottom of my bullets here. There's some trademark considerations. That's when I kind of mentioned them. And so in trademarks, you need to think about the use of third-party marks in training your data sets. And so there may be some issues there of infringing on trademark if you do so, and the likelihood of confusion and dilution theory. So you could have an image generator like DALL-E 3 create an image that's too close to a trademark. It looks too much like the McDonald's arches or the Nike checkmark, right? And so you need to be careful about the outputs from trademark and infringement perspectives. Moving to the middle set of bullets on the patent law challenges, we have issues around inventorship and when AI contributes to the invention. So there was a Federal Circuit decision in 2022, the Thaler versus Vidal decision, and it held in that case that an inventor under the U.S. Patent Act must be a human being, and it denied inventorship status to the AI system. So just because you have some type of predictive AI or some type of generative AI that can spit out what you think is a new invention, the AI itself cannot be an author. So the Thaler case solidified the inventorship gap in patent law, creating uncertainty about the patentability of purely AI-generated inventions and spurring debate on legislative solutions. And then the main area that I want to talk about here is the first group of bullets on copyright infringement from generative AI. And so there are a range of questions here that are extremely interesting, and I've given talks about them. But one of them is this issue of inputting the training data into the system. So in order for either a predictive AI system or a generative AI or Gen AI to work, it needs to have large volumes of training data. And so right now, the largest AI vendors, such as OpenAI and their ChatGPT tool, they have zoomed up all of the publicly available data on the internet. And in some cases, such as with Anthropic Claude's AI, they've even trained it on pirated works as well. And so there is no more publicly available data or even pirated data to scoop up. And so now that you've done this training, the question is, well, was that fair use? So if you trained your large language model on copyrighted materials, did you infringe on the copyright? And this is one of these important cases. So there's been two recent decisions. One is the BART's lawsuit against Anthropic in California, as well as the Cadre versus Meta platforms lawsuit, also in California. And the principle from these early decisions in these cases is this notion that you can legally, it's okay to train your AI on copyrighted works because it's transformative. That's just how the courts have ruled on this, at least where the data was lawfully acquired and there's no proof that there was harm to the market. So the implication here is that if you did in fact pirate the data, then you may be facing substantial fines. And so in the Anthropic case, this is the Claude AI, they may be looking at lawsuits here. Again, it's really interesting because the pro fair use argument would facilitate the development and deployment of these AI tools, as well as the pro copyright argument would tend to restrict the ability of the technology companies to make these AI tools, but would enhance the ability of copyright holders to maintain control over the technology. And so this fair use, pro fair use versus adaptionist argument is one of the interesting tensions in this area. And I want to point out one other case and then move on, and that's this 2025 decision in Thomson Reuters versus Ross Intelligence. So in that case, what Ross Intelligence used to be IBM Watson, they rebranded it as Ross. They did is they had a third-party vendor take the Westlaw head notes and reframe those head notes. And then they trained the Ross AI on these reframed head notes from Thomson Reuters Westlaw database. And so what was really interesting here is that was not fair use. Even though this third-party vendor had kind of reframed the head notes were copyrighted, and it was a close enough connection. It was not transformative enough for the Ross Intelligence not to be infringing. And so that's an example there of kind of where the boundaries are right now. So as far as practical tips go, if you're in-house counsel for a company, your focus should be on mitigating your IP risks. And you can do this in many ways. Two of them are, one, to mandate data provenance audits for all procured AI. Look at your vendor contracts. Inquire of your vendors, where did the data come from? The reason why you need to ask that question is if your AI vendor is using pirated works, copyrighted pirated works to train the data set, there may potentially be downstream liability for your company because you're using these tools. And again, we've already gone through the phase of AI acceptable use policies for companies, but you need to do this not simply from the cybersecurity point of view of not putting your corporate data or your law firm confidential client data into the system. Also think about the point of view is it going to be spitting out copyrighted information and therefore infringing on copyright? If you're outside counsel looking to advise clients, then the main issue here is litigation and litigation strategy. And you're wanting to argue in terms that there's no market harm with whatever potentially infringing use may have occurred. Is fair use because the market was not diminished. And of course, if you're in the patent area, then the issue here is the administrative gap in making sure you have a sufficient human involvement. So with that, I'm going to ask, does anybody, if you have any additions, and if not, we can jump over to the next area.
So I'll just do one quick spin on all of this that I've been seeing is in addition to the traditional intellectual property laws, there's also potential for breach of contract claims in this area if a party is using information in a way that was not envisioned by the contract or they don't have that customer permission. So I think, it's sort of like another tool in the toolkit for enforcing intellectual property or just wanting to make sure that you're really transparent and thoughtful and aware of how you might be using customer or your business partner's information.
Definitely. And I don't see any questions from the attendees, so let's go ahead and I'll turn it back over to Amy to talk about tort liability and public safety.
Sounds great. So here, this is sort of like kind of pivoting to a different topic area. And I think as we go through, you'll start to see some themes emerge throughout the different topics. But in this area, I wanted to begin by talking a little bit about just the legal frameworks that are out there. There's been a strong focus on sort of an ethical approach to artificial intelligence. So, kind of not just doing what you're legally required to do, but doing the right thing. And part of that is like thinking about artificial intelligence as a tool that can be used for societal good, or having sort of that beneficence in its application. And public safety, the tort area, kind of that whole safety area really ties in with that focus on making sure that the technology is doing good for the public. And when there are bigger risks, and particularly related to safety issues, that there is more scrutiny on the product or the tool, more heightened review and auditing, and just making sure that everything is good to go, that it has really gotten through a more stringent review process, and so that when it goes out on the market and people are engaging with it, that it is safe to use. And on this topic, I wanted to bring up a case Antony and I were talking about that just came out the last couple days. You may have seen it, where a verdict was issued, where Tesla was jointly responsible for the death of people resulting from its automated driver assistant tool, Copilot or Autopilot. And in that case, both the driver and the Autopilot tool were essentially sharing responsibility for this outcome. And I think the jury there was persuaded by concerns that the technology was potentially flawed. It was not fully vetted and ready for a market. It was sort of still in a beta testing phase. And paired with that, Tesla was aware purportedly of some of the deficiencies and issues, that it really wasn't quite ready for prime time, but yet had made a lot of very strong claims about this capability, and had really come out in its marketing materials, its advertising, and really amped it up, and said it was very reliable, very safe, and all these kinds of things. And so I think these are sort of twin themes that we're starting to see in the torts and safety area, as well as others. One, what is that division of responsibility between the parties when they're using an AI tool? And also, how is a company talking about and articulating what that tool can do? And where I sit, doing a lot of work with the federal government, there's, I think, going to be more scrutiny and more review of underlying documentation or evidence to support the claims that companies are making, particularly in the government procurement space. But I think the same, could be true, or, is likely to be true in other commercial contexts as well. So some really interesting things happening here. But I think that, if you take a look at that Tesla case, it's a really good overview of kind of what we're talking about and what some of these issues can be in practice.
Yeah, I think this really
Yeah.
interesting case, Amy. It's great. Glad you brought it up. From an academic's perspective, one of the questions behind the legal system's application of existing laws to autonomous vehicles, self-driving cars, is whether or not we need to have an entirely new legal regime or not. And it's kind of this debate I hinted at earlier on the copyright issue of, do we just apply existing laws? Or do we need to basically have a revolution and have brand new laws here? And I think that the jury verdict in the Tesla self-driving fatality case suggests existing laws are adequate. We can apply existing tort laws around liability and negligence to allocate risks and do so in ways that make sense. And another interesting question around this that I think has been resolved a little bit is, what is the standard of care? Like, does the reasonable person standard apply to non-human actors like self-driving cars and robotaxis and autonomous vehicles? And it seems like, well, maybe the answer here is yes. And a third interesting issue from this case is that in the European Union, they've broadened the definition of what is a product to include software and AI systems. And so in the United States, a lot of the software services are services. So when you get Microsoft Windows for your operating system, or when you get cloud storage solutions, there's this debate of how do you treat them. And the European Union says, yeah, these AI tools are products. They're not just services here. So that's interesting. And then the last point is a concern that academics have posed about how corporations have developed AI tools. And the concern is that a lot of the outcomes might be harmful, but are not illegal. And so they call this amoral drift because what happens when there's like a negative externality, but there's no law that was broken. And that's a whole other area here that has led to the first overview that Amy pointed out about the 1,000 state bills that are in process. Part of all those bills, all that activity is because of the fact that there's lots of outcomes that are harmful but are not currently illegal. And so that's trying to rein these outcomes in. But those are my points. Back to you, Amy.
Yeah, I think that's so interesting too. And I think, there's always like this conversation around trustworthiness and reputation and reliability that, you can really stand behind your product and others can partner with you because they can, believe in you and trust you. And I think there are some really interesting sort of not legal, true legal kinds of things happening in the undercurrents here that I think people really want to make sure they're watching for. All right, with that, I think it's time for our code word.
Yes, the code word is data, D-A-T-A. The code word is data.
All right, so do we want to do, I'll do one takeaway here. I think that the biggest takeaway is down there in the bottom left corner, the concept of human oversight, just making sure at the end of the day, there's that human in the loop, there's somebody watching this, somebody making decisions. I think that's really, really important to make sure that we don't get so far, dependent on technologies or, reliant there that we're not keeping human oversight in place. So making sure that, as you're building your user guidance and other policies and documentation, that human in the loop is consistently a part of these processes, particularly in these higher risk scenarios.
That brings us to the next section, which deals with employment and labor law risks. And so Amy and I both have extensive experience in this area. I've personally consulted with technology companies and financial institutions around this issue of AI tools in hiring and promotions, as well as in issuing credit and loans, and looking at patterns of disparate impact and bias. So this is really an area that's fruitful for legal compliance. On the slide, the first bullet here is about AI-driven hiring tools and this issue of disparate impact. And so in New York City, Local Rule 144 requires companies that do hiring in New York City that use AI tools to report basic demographic statistics around race and gender about the impact of those hiring tools. And there is a case in California, Mobley versus Workday, where the class action lead plaintiff alleged that the algorithm, the AI hiring algorithm from Workday, had a number of biases and discriminated around race, disability, and age. And so recently, the judge in that case required that the Workday company provide a list of every single employer, every single company that's using their software that turned it on, to try to figure out the scope of potentially impacted individuals. So if you use the Workday AI, you may be seeing an impact here as a potential area as well. Performance monitoring is a big issue here with respect to surveillance. We've heard of the Amazon worker, where the software system programs how many steps you can take, how many seconds you have to go to the bathroom, and people are being treated essentially like fleshy robots. They're being controlled by the software system. And then under state and local regulations, the one I have not mentioned yet is the Illinois Artificial Intelligence Video Interviewing Act, which allows for a private right of action if the employer in Illinois has a video interview and doesn't follow the prescriptions of the video interview, like destroying it at a certain amount of time, or giving the right to destroy it, and that's led to a significant amount of litigation. So I see there is a question in the chat about the code word. The code word is data, D-A-T-A, data. That's the code word. Hopefully you heard that the code word is data. And I see a second question in the chat. Is there any case law or thinking on the impact of AI on the traditional evidentiary foundations or development of evidence? For example, photographs and business records. And the answer to that question is there is a lot of thinking around this area. And I have a separate presentation that I'm preparing on this that I don't have handy, but the existing rules of evidence still apply. So 401, 403, 902, expect the Daubert-Frye standard for expert testimony. So nothing's changed here around providing evidence. The challenge that AI adds to all of this is this question around authentication and denying authenticity. So what happens when there's a deep fake? What happens when the plaintiff claims that Elon Musk made a particular statement and Elon Musk claims he never made the statement? Then that the video or the audio is a deep fake. Then how do you deal with that? And so in the Elon case, he was forced to come into the courtroom and provide testimony that, did you say this or not? And he said, well, actually, I did say it, right? But these issues are out there, particularly for criminal prosecutions with video photographs. So if you have a client who is a defendant in a criminal case, how would you even know whether or not the prosecution used AI-based tools? So that might be a threshold question. And then you may have to ask certain kinds of questions to figure out if they use it. Because normally what the prosecutor will do or law enforcement will do is they'll find some other methodology to basically identify your client as the alleged perpetrator of the harm. So that becomes an issue. And then once you do figure out that they use either like a computer program to identify the photograph or the imagery, then how do you challenge it? Again, it goes back to the Daubert-Frye standard for evidence and expert testimony. Okay, so another question. When an auto-driving car accident happens on the street, is the car producer or operator or driver responsible for the accident? And I've been talking for a lot, so I'm gonna let Amy deal with this question about liability for a auto-driving car accident.
Yeah, I think so. What we're seeing is maybe it depends, which is always our favorite lawyer answer. But I think a lot of these cases are going to be very fact specific. And it does seem like from the Tesla case, at least, that there, can be shared responsibility across different actors. And I think consistent with what we've seen from tort law over time, even outside of the AI context. But it's an interesting question. And I think, it is something that, for companies that are doing autonomous vehicles, whether it's, driverless cars, if it's, Navy boats that are going out and doing interesting things out in the world, there is a lot of question and concern around what are you really signing yourself up for, and how much risk, and what is really being, from a government contractor perspective, what's being asked of you, and how can you shape some of those relationships in a way to insulate yourself a little bit. So it's not always going to go back to a contract scenario, but that can potentially be helpful. Looking at some of those like limitations on liability and other clauses that can help, but are not always going to be dispositive. So I think this is an area, like the rest of it, that's very much evolving. And there's still a lot of risk because there's still a lot of unsettled case law out there. And so being thoughtful and cautious and knowing those different, what is happening in that litigation landscape and what's working and not, I think is going to be really critical.
Yeah. So that leads to this notion here of emerging doctrines around AI vendor liability. And so, as Amy just explained, there's a thought that, look, you just make the contract, and the contract disclaims liability. The Tesla decision from last Friday, our jury verdict suggests that that's not going to be dispositive. It's going to vary on your cases there, case by case. So some practical tips for complying with employment and labor requirements. And I think the key here is aggressively look at the vendor contracts. That's good in general. You look at them for data privacy, look at them for cybersecurity. Now you look at them for artificial intelligence. And in the Workaday lawsuit, it reveals that if you are using their tools, you don't want to be responsible for problems with the software. You want Workaday to identify you as opposed to the other way around of them being, having no obligation to you at all, because you're relying upon the quality of the hiring tool they provided you. And if it's not a quality tool, if it's not safe or appropriate for work, then that's an issue. And I think, again, this is my personal agenda here, is you should have proactive algorithmic fairness audits and bias impact audits. I think you should do that. I think it's a good principle. I will note that last week, the White House released their AI plan, and the White House's AI plan has indicated for federal agencies that they are to promote freedom of speech by removing any references to diversity, equity, and inclusion in the systems. And so an AI bias audit, I would presume, would be the kind of thing that if you're in a federal agency, you would remove pursuant to the White House's AI action plan. So just kind of note that wrinkle there. But I think it's a very important thing to do a bias impact audit. I think it really matters because it helps you to be confident that your software is not inadvertently harming people. And as the Workaday lawsuit shows, even if at the federal level, from the agency point of view, they're saying for the government itself to de-emphasize issues of checking for bias, you as a private civil party don't necessarily get that protection vis-a-vis the people who are using or being impacted by the software system. So I think that's it for this section. I'm going to hand it over to Amy to talk about privacy.
All right. So privacy, if you get back to your privacy foundations and fundamentals, all of that's going to come into play in the AI context. So if we frame this slide around notice, consent, and transparency, that's really the key as you think about privacy risk and how to mitigate against that risk when you're developing or deploying AI solutions. I'm going to talk about 3 hot topics here that I think are really interesting. This is one of those areas where there's a lot going on. We could talk about this one probably for a full hour in itself, but I think it's just interesting and worth flagging a couple things we're seeing. One, the biometric data point here. There's been a lot of interest by employers and employee monitoring over time. So if you think about monitoring behaviors for insider threat concerns, monitoring data loss, trying to avoid data escapes, as we call it, and making sure that things are kind of on the up and up. But now with artificial intelligence, that monitoring can get to a whole new level where you can really compile and assess that data and run a lot of interesting analytics on it. So we're now able to look at our employees in a much more holistic, some might say invasive way than we ever did before. But it really allows companies to baseline user behaviors and activities, identify when there are variants from those things so they can detect insider threats or data loss early on. But that level of oversight really does raise some interesting privacy questions And so there's some tension there that I think is worth watching for and just being aware of. Another area that has been pretty interesting, something I've been working on, and I think a lot of people in the legal community have been thinking about, is now there are these AI capabilities that can sit in on your meetings. And so whether that is an AI note taker that can just listen and give you a summary or key takeaways or to-do action items. There's some pretty widespread tools that have come out. The Microsoft Teams platform has a premium and the Copilot. So there's all these new tools that allow people to really engage with meetings very fully, but also require recording and transcription. And that gets into some of these, the wiretapping rules, the notice and consent rules. And so it's been a really interesting and challenging landscape to navigate through, figuring out how to realize the efficiencies and the value of these AI tools, but not blindsiding people or inadvertently violating privacy requirements by having those capabilities inherent on these systems. So that's definitely been an interesting area to watch. And it has really kind of morphed into some emerging litigation. And so where the IP related litigation has been a very hot topic, it seems like a surge of interesting privacy litigation is rising as well. And it is related to some of these recording capabilities. And one of the areas where we're seeing it is in the context of a health provider relationship, for example, where a provider might be gathering initial information from a patient or a prospective patient. And so they're gathering, health information, personal information. And off to the side, there is an AI bot that's listening to this conversation and taking notes so that the provider can then use that in the future to help triage and manage that individual's care. But when there is no notice or awareness of that kind of thing happening, it is an issue, and it has given rise to some interesting litigation. So making sure that privacy notices, privacy statements, initial notice and consent pop-ups are available. There's a lot of different things you can do to mitigate those concerns, but definitely seeing, privacy continue to take on some interesting new shapes in the AI landscape. And definitely, one of those threads to always watch for in AI use and development. So lots of things, that are good to do here. Privacy impact assessments is becoming a more prevalent legal requirement under certain statutes. The GDPR, if you do global business, is always going to be something to watch and make sure that you and your business partners are adhering to. And really, again, just kind of getting back to those, the data minimization, transparency, notice, consent, confidentiality, all of those core best practices in the privacy area, continue to be of amplified importance when you're talking about AI. So making sure to carry those things forward and watch for different AI use cases so that all of the privacy documentation is well aligned and you've got good coverage.
So this brings us to, I think this is the last major section before the conclusion part, where we're going to talk about black box algorithms, vendor liability, and governance. The issue of governance, I think, is very important. And when Microsoft Corporation required Windows 11 users to use Copilot, and you could argue with them on the phone for a couple hours, they might turn it off for you. I couldn't figure out if it actually worked or not. So they kind of forced most of corporate America to just adopt their AI tool. It made it very clear to a number of companies that data governance is a big deal, because you'd have situations where a secretary in one division would ask a question, and get private personal HR information about people in a different division to which the secretary had no right, to proper access that data. And this is really important here, because knowing the controls of who should possess it, who doesn't possess it. So thinking about governance is a big deal here. So on the slide, the first major area is the risks around opacity. And this is just this idea that there could be pros and cons with litigation to state level. So the way courts have treated the actual algorithm behind AI tools is as a trade secret. It's a secret sauce. And generally, there's no obligation to provide that secret sauce. It requires a great burden to make it available. And so thinking about this opacity around that could be both good and it could be bad. And if you're defending against a claim and you want to assert that the algorithm was fair or unbiased or didn't make a mistake, then you may have issues if some other vendor provided the algorithm and they won't permit you to see through the opaque window into the algorithm's functioning. A second big area here is vendor and supply chain liability. And again, this is going back to the Workaday lawsuit and the Tesla lawsuit, and thinking about whether contracting can be used and to what extent it will be effective in limiting liability for the tool vendor, and how much of that liability would be based upon the user of the tool, whether you're a company that's an employer or you're the driver still driving car, how much of that will you bear, and what will the indemnities look like, if any, in the liability? And so again, I'm very strong here on data governance and this idea that it's extremely important to think about the ways in which your organization handles cybersecurity, data privacy, and artificial intelligence, AI, collectively. And so you need to have policies around this. You have policies for data privacy, you have policies for cybersecurity, you have policies for AI use. And you want to be ethical in the use of the AI and make certain that you're respecting the rights and freedoms of all parties, whether it's a state law or a federal law, or just kind of thinking about best practices in your industry for how to use the tools. And so the way you get here are through risk assessments and impact statements. The NIST has a number of frameworks. They have an AI framework, cybersecurity framework, data privacy framework. And here you look at the AI's risk management framework from the NIST is a good starting point for thinking about responsible AI governance. But the basic principles are basically fairness, accountability or accuracy and transparency are the kind of the core values here. And you want to have documentation around your accountability structures. So if you do business in, say, California or in the European Union, there are existing laws around documenting the processes and structures for how you use the data, particularly the EU AI Act. There's provisions there. And if you look at those thousands of state level bills, many of them have provisions around documentation and accountability. So again, we as lawyers are really good at documentation and regulations, and we're really good at looking at these compliance checklists. Well, that's exactly the kinds of things you need to do around artificial intelligence in those systems. So these tips here are pretty straightforward. AI is not a single sector of your organization. It's not just the IT folks. It is really cross-functional, and it's not just the United States. If you have business outside the US, or if you have clients from other countries, it can be international. And you need to immediately, if you don't have one already in place, adopt a comprehensive internal AI use policy. And that AI use policy needs to, at a minimum, cover confidentiality, accuracy, and if you're at a law firm, billing, right? So if you're using AI to draft a client legal memorandum, or draft an employment agreement, mergers and acquisition agreement, entity formation, or some kind of contract, then think about how that impacts your billing. Is it something that you can bill the client for, and if so, how? And be certain to invest in mandatory comprehensive AI training in your organization. Again, other CLEs, other briefings where we've talked in detail about how lawyers, judges, prosecutors, practitioners are misusing these AI tools and getting burnt because of the misuse. So knowing from a competency point of view what the tools can and cannot do are really important for your organization. And I'm going to hand it over to Amy.
All right. Well, we've covered a lot in a very little amount of time. And as we've said, we could have taken any one of these topics and spent an afternoon on it. It is an area of the law that is as deep as it is wide. There's so much going on here. It's complex, it's fluid, it's changing, dynamic, all those words. And that's really why I love it. I think you can tell from both Antony and I that we are intellectually curious and we love the challenges and the problems that this new technology presents in our practice, and probably is, just the beginning of what's to come in the future. And so being on the forefront of those really exciting changes is a really fabulous place to be. So, you will take with you that knowledge that this is a really complicated area. Often not something that you can do alone. You're going to need subject matter expertise across some different areas, but a really, fun and rewarding place to dive into. And it is going to be, I think, critical for all of us to have this knowledge, as this is the way of the future, whether you're in a law firm, a company, the government, academia, wherever you are in your practice, it's going to be there. So we talked about 5 different areas that are really critical. And again, this is a touch point. It's not the end of the story, it's the beginning. So we went through intellectual property issues, tort and safety issues, employment and labor law issues, privacy, and then kind of the overarching governance structures that really help us identify and manage that risk. So these are really some of the big buckets that we see in AI and think are really important to share with you. And any one of those, is certainly, open to more digging in as you go along. Some key compliance things to think about as we wrap up here. Really the data is at the heart of all of this. So thinking about, where does that data come from? How is it being protected? What data is used? How long is it stored? Data rights, and kind of all of those different things are very much at the heart of everything that we're talking about. We want to make sure we're watching out for bias as an AI tool is being deployed, and how does that affect its reliability and our engagement and our reliance on those tools. Who's going to be accountable? Definitely an open question, as we've talked about, that there could be enough responsibility to go around. So we want to make sure that we're well positioned through the right governance structure, the right documentation, the right ethical approach to all of this, so that we are in the best position we can be to make sure we are accountable, we're doing things right, and we're limiting to the greatest extent possible our liability. We want to make sure that there's transparency and understanding around what we're doing, so that those who are using these technologies understand and have the ability to ask the questions they need to about AI outputs, and that they're not being really kind of given incorrect or false information that overstates capabilities and doesn't provide them with ground truth. And then finally, and this is really, I can't foot stomp this one enough, documentation of what you're doing, how you're doing it, how decisions are being made, what the tool does, how are errors corrected, the cybersecurity compliance requirements, the privacy requirements, all of that, having a good foundation in documented evidence to support your claims and support the use of the AI tools. So really, really critical, and an area I think where we as lawyers can be very helpful. So lots of good takeaways here. And then I think we've got just some closing remarks and might have a couple more minutes for a few questions.
Thank you, Amy. So last ideas for wrap up. We're going to land this plane. Here we go. So 2 takeaways for tomorrow or Monday morning. One is, consider spinning up a cross-functional AI governance working group. I think that's a really great idea. Bring in legal, bring in technical, bring in your business leads. That's a good starting point. And then number 2, you need to adopt a risk register for your AI projects. So think about it like this. Have a ranking of the likelihood times the impact. So you can see where you should focus your resources, and maybe you just aren't using that much AI. But I have an intuition you're using more than you think you are, and you should probably make this register so you can be aware of the risks associated with the AI. Again, this is the first in a series of presentations, so there'll be more to follow this workshop to CLE. Please be sure to complete the survey and email the emails in the survey as a PDF document. You can fill the PDF out to Lisa for this. And so that's really important. And let's see, are there any more questions? Yes, there's one more question. Let's see. So glad you did this course as we move to automating all of our systems in our franchise development. How do you recommend scaling this information for a smaller growing business? How do you recommend scaling this information? So I will let Amy take the first hack and then I'll jump in.
Yeah, so I would say, and I'm at a very large company now, but I've worked at a very small one as well. And I think that I would begin with an understanding of risk. So maybe getting to the risk register comment that you just made, or looking at it a little bit more broadly. So kind of figuring out what are you using it for? How much risk is there? Are there safety implications, privacy implications, other things that really, tip it into those areas that get more scrutiny. I would probably avoid decision making at the beginning, but I think there's a lot of safe space in, things that we think about as just automation that move things faster are actually in many cases AI driven. So you could already be doing those things today. So things that help with efficiencies, automation, a lot of those day-to-day activities I think are going to be a pretty safe space. But I would probably start in that lower risk area. And then as you find utility and purpose in those tools and those repeated activities, to move into more of the risky areas as you have the risk capacity, the financial resources and infrastructure to support moving to that next step.
Yes, exactly. And don't be afraid to have a lawyer consultant like Amy, like me, come and help you out, because this is really hard to stay on top of. This AI stuff impacts everything about everything. And I spent the month of July just trying to use the most popular tools like Westlaw's Precision's Co-Counsel and LexisNexis's Protege, and Claude and ChatGPT and Gemini and Perplexity and Grok and like all these tools, and I finally feel like I have an understanding of what they can do at this moment in time. But they're constantly adapting and evolving and changing, so you have to stay up to speed on all of that, which is really incredible. And there'll be very subtle things you don't realize. For example, Sam Altman, who is the CEO of OpenAI, which controls ChatGPT, which is about 82% of all of this AI stuff on the internet is ChatGPT. He said there's no privacy. There's zero privacy. So if you as a lawyer have been typing questions, or even as a non-lawyer, you've been typing these legal questions into the ChatGPT, you may have screwed yourself, because now you go to court and all that is discoverable. Like there's no defense for all that. Now, in contrast, Elon Musk has claimed that XAI or Grok is going to maintain privacy, and I don't know how they're going to deliver that guarantee. But at least one of them is letting you know that there's no privacy here. But again, there's all these little things you don't think about because it's so useful. It's so useful to use ChatGPT to write your legal brief. Well, maybe your thought process is embedded in there, and now this the work product is now going to you basically waived the protection on it. So don't be afraid to get a lawyer or consultant like Amy or me to help you out. We'd love to do so to help bring things in. Well, I'm leaving the floor open one last time. Are there any additional questions? This is the merit ceremony. My dad was a minister. He said, "Speak now or forever hold your peace." Speak now. Last reminder, please complete the surveys. This is how we improve the courses. Your topic suggestions will be the topics we pursue in the future workshops. If you have any questions for me or Amy, our email address is here on this slide. And also, just want to say thank you so much for spending this hour with us. we know your time is very valuable and you're very busy. But we deeply believe that if you're proactive in looking at the risks around AI and just competent in how you use it, it's going to allow you to be more successful in as a lawyer or in your endeavors. Okay, so I think Tom, it goes back to you.
Thank you, Antony and Amy, for your amazing insight on this extremely wide, as Amy said, wide and deep topic. I want to thank our attendees. I want to thank you all. I want to thank the staff that have worked to put together this series. And we look forward to seeing many of our guests again for next week's event. Check it out on our website if you haven't seen it on the 12th of August. But until then, have a great day, everyone.